Hi, folks. We're going to be starting in about a minute or so. So you're welcome to come in and do your audio check to make sure you can hear the presentation. Thank you. Good evening, everyone. My name is Deanna Kimball, and I'm the PSAC BC Regional Education Officer, and welcome to Bill C-65, the new Workplace Harassment and Violence Prevention Regulations Overview. Before we get started and I turn it over to our presenters, I just wanted to go over a few housekeeping items for folks. So if you haven't used GoToWebinar before, you'll notice in your platform that there's a way you can open and close your control panel using the orange or red arrow at the top of the panel. You have two options for joining the audio. You can use, you could choose to use your microphone and speakers and use the voice over internet or the VoIP, or you can call in using your phone and dial using the information that was provided in your confirmation email. During the presentation, you are more than welcome to submit questions or comments via the questions panel. Or if you're having any technical difficulties, you can write that into the questions panel as well. Today's presentation is being recorded and it will be shared and posted on the PSAC BC website. Another option you have for indicating if you need any immediate attention is you can raise your hand. There's a little hand icon and you can raise that and one of us will check in with you. There are handouts that you're welcome to view. You can take time to download them during the presentation. You're more than welcome to do that and save them for your future use. So I'm going to turn it over to Sharon Barber, the PSAC Regional Rep for Health and Safety, and let her take it from there. Thank you.
I was just trying to unmute myself on the unmute button on the slide here. Good evening, everyone. I did find the correct button eventually. Hi. So the first thing I would like to start with is an acknowledgement that I am joining you today from the Coast Salish homelands of the Musqueam, Tsleil-Waututh, Squamish, and Stolo nations. Each one of us attending this event is joining us from traditional Indigenous territories. Just take a moment to reflect on the history that brought you and each one of us to reside on these territories, how our ancestors and how we today are affected by and continue to participate in colonialism. Thank you for that. The REVP, Jamie Mills, cannot be with us tonight. So Linda Harding, the Health and Safety Coordinator from the PSAC BC Regional Council and the RVP for the Government Services Union is here with us to share greetings. So Linda, over to you.
Thank you, Sharon, and Jamie does send his regrets. As Sharon has already introduced myself, but I'll just say it's great to be here today, and unfortunately I can't see you, but I hear that there is a number of people on the call, so I'm very happy to hear that. I want to thank you for taking the time to join us on this important webinar, and to thank you all for all the work that you have been doing. It's very important. The new regulations coming into force on January 1st will help better prevent and actively address harassment and violence in the workplace. They are long overdue. PSAC welcomes them, and we believe that they will help provide much greater protection for all the workers of the federal public service. I encourage you all to participate in your local or branch joint health and safety committees, as well as the PSAC's Regional Health and Safety Committee, which is otherwise known as BRUSH. For your information, do not hesitate to reach out. For more information, do not hesitate to reach out to Sharon or myself. We would love to have folks on the call today to join our Health and Safety Committee. I hope you find this webinar useful and informative. And back to you, Sharon.
Thanks, Linda. So I'm going to take myself off of the camera and we'll start moving through the slides. The presentation takes between 45 minutes, somewhere around there. And then we'll have time for questions at the end. If you have questions during the presentation or comments, please feel free to enter them into the questions box. Thanks. So on the agenda, we are going to be looking at the basics of Bill C-65 and the attached regulations. This is a basic introduction, a really quick overview, and will provide some additional resources to assist you in your workplaces as you move forward. These changes come into effect on January 1st. So it's important to keep in mind that it's a different process as of January 1st, but we'll be here to support you. We're going to talk a little bit about why these changes are important to us and our colleagues. I want to look and outline the provisions in the sort of the three pillars that are represented in the legislation. That's the prevention, response, and support processes that are outlined in the legislation and regulations. As I mentioned, we'll talk a little bit about some of the resources available to you and your colleagues, and then take some questions and comments, and then we'll be free for the evening. So I'm going to start with a poll, and the question is, what level of knowledge do you already have about Bill C-65 and the new workplace harassment and violence prevention regulations? So you either are feeling very familiar and you know a lot about it, you're somewhat familiar, so you feel you have some information, but not all of it. You've heard of it, but don't know much about it, or there are upcoming changes about workplace violence and harassment, so maybe you've never heard of this. So take a minute to tell us a little bit about the level of knowledge that you feel you have already. So we actually don't have a single person on the call who feels very familiar with the changes. Yesterday we had a few, we did this yesterday at noon. We did have a few people that felt that they were very familiar. About 30% of you feel that you're somewhat familiar, so you have a bit of information, which is great. The majority have heard of the regulations but don't have a lot of information, and there actually are a number, which doesn't surprise me, who haven't heard of this at all. So I'm glad you're all here, and hopefully we can give you all a little bit more information. And thank you for sharing your response. So this is the down and dirty basics. Bill C-65 was passed through Parliament in October of 2018. and it amends the Canada Labour Code to make psychological injuries and workplace harassment and violence part of the health and safety hazards and incidents that employers are required to prevent under the law, respecting their health and safety responsibilities. So in many ways, this was already the case. The legislation spoke to violence, workplace violence, and it's been acknowledged and recognized for quite a while that psychological violence and injuries were included in that, but employers weren't really always seeing it that way and weren't doing a lot of preventative work. So it was very important to see this formalized, and it's going to mean, I think, a really big and positive change for our workplaces over time. So in addition to the changes in the Canada Labour Code, we have new regulations that outline the requirements the employer must meet. They're the workplace harassment and violence prevention regulations. These regulations are attached as one of the handouts here. These are new standalone regulations that replace Part 20 of the Canadian Occupational Health and Safety Regulations. So people that were familiar with addressing violence in the workplace through health and safety mechanisms in the past would be familiar with Part XX or Part 20 of the regulations. That no longer exists, and these are new standalone regulations. Again, they outline sort of these three pillars: that the employer is required to prevent against occurrences of harassment and violence, they're required to respond to those occurrences, and they are required to provide support to employees who are affected by harassment and violence at work. So the definition of harassment and violence as outlined in the regulation is any action, conduct, or comment, including of a sexual nature, that can reasonably be expected to cause offense, humiliation, or other physical or psychological injury or illness to an employee, including any prescribed action, conduct, or comment. So this is a very broad definition, and it could mean anything from teasing and bullying to actual physical violence in the workplace. It's broad, and that, I think, is going to be helpful as we move to make our workplaces more respectful. So why is this important? And there's two quotes that kind of impact me deeply. I wanted to share them with you. If you've spoken to me before about harassment and violence at work, you may have heard these before. The first one is from Bernice Fields. She's an arbitrator who in November 2000 dealt with a grievance from the United States Postal Service with respect to violence in the workplace. People who grew up in the 80s would certainly be familiar with where the term going postal comes from. The United States Postal Service dealt with a number of extremely violent incidents in the 70s and 80s that led to a large number of fatalities, unfortunately. There was a grievance related to some of the changes that happened in the workplace, and Arbitrator Fields, in her decision, wrote that violence in the workplace begins long before fists fly or lethal weapons extinguish lives. Where resentment and aggression routinely replace cooperation and communication, violence has occurred. The next quote is from the Ottawa Transit inquest. So in the 90s, the Transit Corporation in Ottawa also had a very serious incident of violence. And the inquest that occurred found or recommended that workplace violence be defined not only as physical violence, but also as psychological violence, such as bullying, mobbing, teasing, or ridicule. So I'm just gonna give you a minute to think about the quotes. If you do feel you want to share a comment or reflect on your reaction, and have that shared with the group, please feel free to enter your statement into the questions box, and I can share that with people. And I'll just go on mute for 10, 30 seconds to give you a chance to think about it and decide if you want to comment. So the reason that these quotes have an impact on me is kind of number one, the date. So, these are decisions being made on events that happened well over 20 years ago. And we're just today getting to the point where these recommendations and comments are being reflected in the legislation that our employers are bound to. And I mean, it's an important way forward. It has taken too long, but it's a victory. The PSAC and other unions have fought long and hard to get this recognized. The other thing that I think about when I reflect on these quotes is the spectrum, but the escalating nature of violence. So teasing and bullying, they can lead, if they're not addressed, to harassment and discrimination. And that in turn can lead to violence and very serious physical outcomes for people. So both of these quotes speak to the link between psychological and physical injuries. One of our participants shared a comment that they have been in a workplace unit, which was, as arbitrator Bernice Fields mentions, individuals had to decide if they wanted to stay or leave because the situation was a gray area with no management assistance. So I assume this is a workplace where resentment and aggression routinely displace cooperation and communication. That, according to arbitrator Fields, is violence. Another comment, this is important because I've been through systematic and institutionalized violence. Over time, this damage wears on the psyche, it erodes self-worth, and it leads to psychological debilitating problems. And that's absolutely true. We know that bullying, harassment, and psychological violence make people sick. Physical violence can injure them, and psychological violence can injure workers as well. So thank you for everyone who shared their comments. So just as I mentioned, the research and statistics show that incidents of harassment and violence escalate when they're not addressed. Conflict does not go away just organically. And unfortunately, we've had to put it into the law to ensure that employers are aware of their obligations to address these issues at the earliest possible stage. We also know that when there's an emphasis on prevention of workplace harassment and violence, there is a decline in the number of incidents over time. So simply by turning our mind to think about how we can prevent it, what we can do to make things better, just by taking that approach, will actually improve things. So you'll see when we get to one of the 3 pillars, prevention, that it's actually a part of the legislation the employer is required to do, is put their mind to how to prevent workplace harassment and violence. Like I said, and like one of our commenters said, workplace harassment and violence makes people sick. It injures people and it makes them sick. We know that there are a number of increasing numbers of psychological injuries, and those are just reported injuries. Often these injuries and illnesses are not reported, and or the workplace is not always recognized as a predominant factor in those injuries. Racialized, Indigenous, and LGBTQ+ workers are at higher risk of workplace harassment and violence, and we need to do something to ensure that they enjoy the same levels of safety, both physically and psychologically, as many of us do. So I mentioned the 3 pillars: prevention, response, and support. I'm going to look at each one of those in turn. Again, it's a brief look, but I think it'll give you at least a general idea of what the legislation and regulation requires. So it's a key obligation of the employer to work jointly with health and safety committees, and health and safety committees are comprised of employee representatives. In unionized workplaces, those representatives are selected by the union. So these are our union leaders who are able to work jointly with the employer to develop a workplace harassment and violence prevention policy, and the regulation itself outlines what that policy has to contain. To conduct risk assessments and to develop and implement prevention strategies. So to look at where the risks are to experience workplace harassment and violence in each workplace, and then put their mind to figuring out what they can do to prevent those occurrences. The legislation expressly requires the employer to address circumstances external to the workplace, and it specifically mentions domestic violence. So they're saying that your obligation, employer, does not start at the threshold to work. You need to look outside of the workplace when you put your mind to prevention. This would also involve those of us that work with clients, members of the public, in person or on the phone. You know, the employer can no longer say, well, we don't control these people, there's nothing we can do about it. It would include third-party contractors as well, and or other employers, you know, other employers that sometimes we share space with. Instead of the employer telling us, our employer telling us there's nothing they can do, they're actually required to consider it now. They have to create and post emergency procedures for incidents, serious incidents of harassment and violence in the workplace. And they have to develop and implement workplace harassment and violence prevention training. And that training is going to be for you as employees. It's going to be for designated recipients, which we'll talk about soon. Those are people who receive work notices of occurrence of harassment and violence. Managers will need to take this training. So it's going to be the entire organization that this training will be provided to. And the employer is also required to implement recommendations that come from the investigations that occur through this process. And we'll talk a little bit about investigations when we get to the response slide as well. So that's the prevention pillar. The response is slightly different than it was in Regulation 20, but it is similar. Step 1, the employer is required to respond to notifications of occurrences of harassment and violence. Those notifications may be oral or they may be in writing. And it's actually now possible for witnesses to notify the employer anonymously of occurrences of harassment and violence. Step 2, you would move on to a point where the parties make efforts to resolve the issue. If it can be resolved without an investigation, this is the stage where it would happen. One option to do that is through a process known as conciliation, or also known as mediation or informal conflict resolution. That is possible to be attempted if it's acceptable to all parties. So only if everyone agrees can conciliation take place. So the next step, if it can't be resolved, an investigation must be conducted if requested by the principal party. Now, these definitions are in the regulation, but the principal party is the individual to whom the harassment and violence was directed at. And if they wish to have an investigation, regardless of what happened at step 2, that investigation must be conducted. And we know, if you have had the opportunity to either work through a harassment complaint yourself or work with PSAC members and support them through harassment complaints, that decision was in the employer's hands for the most part as to whether to conduct an investigation. It's now absolutely in the hands of the individual who experienced harassment and violence. The investigation report must include a description of the occurrence, the investigator's conclusions as to whether harassment and violence occurred or not, and then their recommendations. The investigator will be selected by the parties, and sorry, I should have fixed this because it's not clear, by mutual agreement of the parties, or they may be appointed by Labour Canada. My next slide gets into that a little bit. The next step is the completion, at which point the investigator's report will be provided to all of the parties involved and to the Health and Safety Committee. The Health and Safety Committee, which is a joint committee of employer and employee representatives, will look at the recommendations and they will decide what will be implemented. And if the Health and Safety Committee decides that a recommendation has to be implemented, the employer doesn't get a choice. They have to implement those recommendations. Another nice change. We often see recommendations made in investigations that are never pursued or implemented. And we're looking at, 10 years later at a new event and saying, look, there were recommendations made 10 years ago and they still haven't been enacted. So this is a good change. So the selection of investigators can be tricky, and we know, for those of us that dealt with the original legislation and Regulation 20, it could often be a source of contention. This regulation says that the investigator must be impartial and competent. And there's a number of ways that they can be selected. They can either be agreed upon by the parties, so the people involved, your responding party and the principal party. So what we may know is the complainant and the respondent will agree on an investigator. Or employers will sit down and develop a joint roster of investigators. So it's possible within some of your departments, this has been done or is being done, where the union and the employer sit down and agree upon a pre-approved roster of investigators. If there is that pre-approved roster, that will be used to select investigators. So in that case, the parties to the investigation will not have input. This may seem confusing for those of you that are interested. I'll give you a resource to look at by the end of the presentation. We'll talk about that. So it's really important that our health and safety committees, when agreeing on this joint list of investigator, that they consider the competencies of the candidates, but especially where it comes to equity and discrimination and human rights issues. We definitely need to have investigators that are competent and experienced and skilled and can look at a situation with an equity lens. So that's certainly something that the union in the development of these regulations brought to the forefront. That you can agree on a list of investigators, but you have to have people that could conduct an investigation of a very difficult human rights issue. So if these regulations are not complied with, there are absolutely resources available, and there's remedies available to ensure that the employer is fulfilling their duties. That would fall under something called the internal complaint resolution process, which is also a process outlined in the Labor Code. It's an escalating process, a little bit like a grievance. If you ever have to use that and you're not familiar with the process, which I know many of our members are not, don't hesitate to reach out to your local rep, to your component rep, or give our PSAC office a call, and we will assist you with the steps in pursuing an internal complaint resolution process if your employer has not complied or is not complying with these regulations. So I'm going to give you just 30, 40 seconds to have a stretch, refill your water. I'm going to go get a little bit more water, and I'll give you a 10-second warning before we get going again.
I just wanted to remind everybody that you're more than welcome to, if questions pop in your mind as we're moving through the presentation, you can enter them into the question section of your panel.
Thanks, Deanna. So it's Sharon, I'm back, and I'll give you just 5-10 seconds to get settled, and we'll move on to the rest of the presentation. It's not a huge amount left, so we'll be getting the questions very soon. All right, so let's see if I can get to the next slide. There we go. So this is what the union, the PSAC, likes in the new regulations. There's a designated recipient. The employer is required to create a role known as the designated recipient to receive workplace harassment and violence complaints. This can be really helpful because often in the past, it was the supervisor who is to receive these complaints, and either the supervisor, number one, didn't know what they were supposed to do with the complaint and took no action. Number two, may have been actually the perpetrator of the harassment and violence, or number three, may not have been an impartial individual who could fairly determine what next steps to take, or could be felt to be trusted by the employee who was feeling they wanted to notify someone of an occurrence of harassment and violence. So, often employees didn't know who to go to either. So these designated recipients have to be identified by employers, and they have to be trained in the legislation and the obligations that they have to act on notifications of harassment and violence. The legislation has very clear timeframes for the steps in the process and resolving the process. And again, if you have ever been involved in or assisted a PSAC member who is involved in issues of harassment and violence, these kinds of processes can drag on for a very long time. And that can really re-victimize and re-injure the person, and it leaves everyone involved in a really difficult situation. So these very clear timeframes are welcome. Just some of the key ones that I can point out is you have 7 days to respond to a notice of occurrence. So if you go to this designated recipient and you tell them of an occurrence, you can expect to hear back from them in 7 days. And if you have not, then you have a reason to follow up and say, oh, by the way, this regulation said you had to acknowledge my concern, and it hasn't been acknowledged. And unfortunately, in my experience, often people will, gather up their courage and go and notify someone of what their experience is and just never hear back. So this is a really big change. There is a 1-year deadline to complete this entire process. 1 year, 12 months might seem like a long time, but again, if you've worked through some of these processes in the past, it can be 2-3 years down the road, you know, that after people have taken leave and gained extensions and made efforts to resolve the situation, that, you know, it's finally coming to an end. And again, that just leaves everyone in a tough situation. One of my favorites, though, is the monthly status update to all parties. So regardless of the situation, regardless of the stage you're at, all of the parties in the process will receive a status update once a month, just so that they know this hasn't dropped off the face of the earth. Things are progressing and moving forward. And I think that will do a great deal to help support people through this difficult process. There is a distinct process for occurrences of workplace harassment and violence that involve a third party. So just as an example, if it is a client or a customer that has perpetrated the harassment and violence, you know, the employer can't compel them to become involved in an investigation, or they may not even be able to find them. No longer can the employer just say, well, we don't know who it was, or, you know, we can't force them to come and talk to us, therefore we wash our hands of it. There is actually a process spelled out for them to pursue when that third party is involved. And I think that's going to be very helpful. There's an obligation to implement those agreed upon recommendations of the investigator. So as I mentioned in the past, in a past slide, when the investigator creates their recommendations, that will go to the Workplace Safety Committee, where employees and employer representatives will decide which recommendations they're going to implement. It's you know, the obligation to implement these recommendations and to have a regulator, Labor Canada, you know, able to follow up and say, hey, you didn't do this, and it's, you know, it's important that you do. I think is a really big change, and it's going to be very helpful. There's a detailed interpretation policy and guideline document, the IPG document, and that is attached here as a handout. This is a 45-page document that is outlined in a question and answer format. It's going to be extremely helpful as we move through the implementation process, and I think it's something that if you think you'll be involved, if you think you want more information, I would highly recommend you look at this IPG. In the past, you know, there was a lot of gray areas in how the violence regulation would be applied. Now, 45 pages of detail, very helpful question and answer format. And I mentioned earlier, if you have questions, you know, with respect to how investigators are selected, that would be a really good place to go and look it up. So if you have a chance, download it. If you don't get a chance to download it from our handouts tab, then don't hesitate to get in touch with the PSAC office, and we'll make sure you get a copy. This document has just been published, the IPG. It's like literally hot off the press, about a week old, which is why you're just getting this presentation now. So I'm not sure if it's available on Labor Canada's website yet, but if it's not there yet, it will be very soon. So you'll probably also be able to get it online. So obviously there are some things that we're not big fans of in this legislation. One of them is a statement that says the employer's decision prevails in joint matters if a decision cannot be reached. So all of these lovely obligations for the employer to work jointly with the union and employees, if in non-unionized workplaces, you know, almost seems like it's just washed away in a statement like that. It's obviously going to cause us some problems, and I think for the initial, you know, year of implementation, it'll be the knee-jerk reaction of employers just to refuse to disagree with everything and tell us, you know, quote the legislation, but our decision prevails. So you know, that's the end of the story. It's not really. If you look at that interpretation policy and guideline document that I mentioned, the IPG, it's very clear that the employer must reasonably attempt to agree and come to an agreement jointly. If they do not agree, they have to record all of the incidents where an agreement wasn't reached. They have to record a detailed rationale for their decision. And if we choose to file a complaint about a violation of the regulation, then a Labour Canada regulator is going to come and ask to see their rationale. It's not going to be sufficient for the employer just to say, well, we disagree. They're going to have to explain themselves, and they're going to have to do it with a very serious safety lens. We anticipate road bumps in implementation. Health and safety professionals have had a few other issues to deal with over the past year. And I think that's a lot of the reason why this is all kind of crashing into us at the end of 2020 for an implementation date of January 1st. COVID has kept everyone busy. And of course, many of us working from home, it has not been easy. A lot of people that I have spoken to did not even know that this was occurring on January 1st. It's going to be a chore to get this implemented. I think it'll be a rocky road, but if we work together, we're going to get this running smoothly. And I'm excited to see the results. The resolution/conciliation stage. So that was step 2 in the resolution process. We can imagine undue pressure being applied at that stage to discourage employees going to an investigation. Investigations are expensive and they can be disruptive. And, you know, employers have an initiative to avoid them where they can. So we want to watch carefully to ensure that the employer is not putting pressure on any of the parties to avoid having to move to an investigation. Again, I think this is something through implementation, through working with employers, principal parties, etc., we'll be able to get through, but it's something we need to watch for. The employer could absolutely refuse to agree on implementing any recommendations. And I kind of mentioned that type of employer earlier, where they just cross their arms and say, well, our decision prevails, so we're not going to implement any of these recommendations. And that's the bottom line. And we'll be watching for that. And certainly, I think it will be time if we find employers are taking that position to get the regulator involved. And that would be through the informal complaint resolution process that I mentioned earlier. If you're not familiar with the informal complaint resolution process, it's a very simple, elegant, escalating process, and I personally would be happy to walk you through it if you find yourself in a situation where you are concerned that this regulation is not being complied with. So it's something very important for those of us that provide representation to PSAC members is to think about the remedies. The Labor Code and the Workplace Harassment and Violence Prevention Regulations are prevention focused. So none of what we've talked about today offers remedies for employees who are affected by harassment and violence. We know the Canadian Human Rights Act and our collective agreements prohibit harassment based on prohibited grounds of discrimination. And we know that the Workers' Compensation Act provides benefits to workers who suffer psychological injuries as a result of harassment and violence at work. So I really urge our members and our representatives to use the harassment and violence regulations. It gives us a great deal of power, especially when it comes to ensuring an investigation occurs if one is required and the issue can't be resolved. But these members also have to consider filing grievances, human rights complaints, and or workers' compensation claims when they are seeking leave reimbursement if they've used sick leave, or annual leave or leave without pay because they couldn't work because of the violence or harassment. They're seeking health care for their mental health. If they are looking for workplace accommodation to address some of their concerns. If they're seeking human rights damages for pain and suffering, lost wages, lost opportunities, etc. The health and safety process will not provide that. Grievances, human rights complaints, and WCB claims will. Very important to keep in mind. So this is all related to federally regulated workers. Majority of PSAC members are federally regulated. If you work for the Federal Public Service, you are federally regulated. We do have a smaller number of provincially regulated workers here in British Columbia, and many of our family members and friends are provincially regulated workers. So it's important to point out that these processes don't apply to them, but harassment and violence are also prohibited under provincial health and safety legislation. You can learn more about that at WorkSafeBC.com. If you know of someone that is experiencing harassment and violence or is looking for more information about it in a provincially regulated workplace. If you have any questions about whether you're provincially or federally regulated, you know, just call Labour Canada, call WCB, and they'll tell you, they'll help you sort it out. Or call my office, and you know, we will work with you to determine whether you or one of your family members or friends is provincially or federally regulated. But what we've talked about is strictly federal. So I promised to mention some of the resources available. There will be an updated PSAC toolkit for preventing harassment and violence, and that's coming soon. I don't have the exact date, but hopefully early in 2021, we'll have a toolkit for our local representatives. I mentioned the Interpretation of Policy and Guideline, or the IPG document that's in the handouts here. Very, very helpful document. We look forward to seeing more Labour Canada guidance. They have a number of publications available for other portions of their legislation, and we assume that they'll be having additional publications with respect to C65 and the new workplace harassment and violence prevention regulations. I mentioned under the prevention pillar, the employer is going to be providing training. We expect that to come sometime in the next 12 months. I don't think you can expect to get to work on January 4th and be provided with training in workplace harassment and violence prevention. The Labour Canada has indicated that they are giving some level of grace period. Again, likely because health and safety professionals have been kind of tied up for the last 9 months or so. But you will be receiving training from the employer. And if you don't, let us know. And PSAC education. So we absolutely, this is a very brief overview. We understand that. There is education opportunities being developed by my colleagues. And right now we're looking at rolling that out virtually, but hopefully we'll all be back together in person one day soon. And I hope to see you at a course specifically related to this topic. So thank you very much. That concludes the presentation, and we're ready to move on to questions and comments.
Awesome. Thank you so much, Sharon, for all of that great information. We had a few questions that have come in, so thank you everyone for those questions. So I just wanted to start with one that was talking about, what about workplaces that are too small to have those larger health and safety committees or to actually have on-site safety reps? What happens with those workplaces? You can unmute yourself. There you go.
Yeah. I know we have some of those small workplaces, fewer than 20 people, where there is no health and safety representative. because where a workplace is too small to have a committee, the legislation acknowledges that those workplaces have to have a health and safety representative. And sometimes our workplaces don't have those either. They're so small that no one wants to take on the role. You know, in that case, I think that I would be working with management to ensure that the you know, the processes are sorted out to suit you and your workplace, because that representative, that health and safety representative, is responsible for a lot of work, joint work between the employer and the employees. So if there is no health and safety representative on site, then we need to sit down with the employer and figure out, okay, so how are we going to make sure that this work is done in a way that reflects the needs of this specific workplace?
Okay, thank you. So what happens, another question that came forward was, what happens if the parties actually just don't follow the timeline at all? So I'm assuming all of the time, the parties. So you were talking about extension generally is by mutual agreement. So what happens if nobody's following the timelines? Do you go to other processes, such as Section 127?
Yes. Yeah, that's perfect. I love it. 127. So yeah, if the timeline's not being adhered to, I would absolutely move to an internal complaint resolution process. And again, that's a process so sweet and elegant, and it works so well. And the first time you do it, you're going to fall in love with it. So call me and I'll help you do it.
Yes, and the further to that, there was also another question that if the person who has filed the harassment complaint, if they go on leave, are they able to have some sort of understanding about extending of that 1 year timeline?
So I think what would actually likely happen, you know, and I've seen this happen a lot when someone has experienced harassment and violence, they are sick and they go off, and sometimes they go off work for a long time. I think what would probably in this case happen is the investigation would actually continue based on the information available to those individuals, because it can be very problematic to have, if it's not the principal party themselves, then it's the responding party, right, that may be off sick and the whole thing gets stalled. So my understanding is that this process will actually continue, and in the absence of the ability to speak with either the principal or the responding party, then they'll just have to move forward in a similar process as though there was the third party perpetrator, without the benefit of the information, so that they can move to, again, to prevent workplace harassment and violence from occurring again. This isn't about remedies, this is about prevention. You know, it's something I haven't thought too much about how it would move forward, but I think those 12 months are, you know, the employer has to have something done in those 12 months. And I think that will be pretty set in stone.
So in other words, just waiting the time and waiting for the person to come back to start the actual process is probably not what. Well,
I don't think that's how it's going to work. And especially, you know what, if it's a month or 2 or 3, that's one thing. But when you get into people being gone for a year or 2 or 3, which I have seen, unfortunately, you know, the process does have to continue to ensure that that prevention pillar is safeguarded.
Yeah. So there was a question in there. This person specifically had a member who applied for WorkSafe BC, and there was a complaint was turned down. The complaint was with respect to violence and harassment, because they were told that there's federal entities to deal with that. So I don't know if you have any comments about that specifically, or maybe that could be something we could follow up with afterwards, maybe.
Yeah, I would like to hear more about
information. Yeah.
Yeah, I mean, you know, it could be anything from, well, actually, they were telling you that you're federally regulated, so don't bring your health and safety complaints to WCB. Or it could have actually been a WCB claim where their claim was denied for reasons that aren't clear. But I would be very interested to follow up and learn more about that question, so I can give a better answer.
Yeah, that'd be awesome. So we'll connect folks to Sharon. I did put her information in the chat, and you can definitely find her information on the PSAC BC website. There's a couple more questions that we had. So one was with respect, so similar to human rights complaints, and when something has happened, is this the same type of understanding if the person who's filed the complaint, if they decide to, you know, if the incident happened less than a year ago or so, are they able to file a complaint up to a certain time period, or is there specific time frames about that?
I think it's a year. You know what? I actually have to look and see.
Yeah.
I
think
that's the one
yeah.
time frame I didn't pay attention to.
Yeah. So
And for former, for former employees, so this also contains a provision which I didn't talk anything about, that former employees can file a complaint, and they have 3 months after their employment ends.
Yeah.
So there are definitely timelines, and I'm pretty sure it's 12 months.
Yeah. We had an interesting question yesterday about, so folks were very concerned about, you know, who is being designated as the person, the contact person. But one of the questions we had was, I'm sitting on a health and safety committee and I've heard nothing about this, or I'm the actual health and safety committee and I haven't heard anything. What should I do? What should be my next, just to kind of reinforce that for folks?
Yeah, because again, this is, you know, people, I think we're all behind the 8 ball when it comes to implementation by January 1st. And, you know, for people that are just learning about this now, there's a lot of information, and I'd be also concerned if I hadn't heard anything from my employer about how this is going to be implemented. So that would be the first person I approach, is the employer. If you're on a health and safety committee, go to the co-chair of the committee and say, what's the situation? Provide us with a status update as soon as possible. But again, you know, I think the situation itself merits a little bit of patience. And unfortunately, I wouldn't be surprised if some of the health and safety co-chairs haven't heard about this, because again, health and safety committee meetings have been very busy places lately, and very consumed with COVID. Employers were asking to have this put off, but the regulator said no, it's been put off long enough. So we're lucky to have it moving now. Ultimately, though, the people I would go to is management. If you don't get answers from management, connect with your local representatives and your component representatives and find out what conversations are being had at the regional or national level. So there's also a policy committee, and they're likely working on developing the harassment and violence prevention policy. And they may have a little bit more detail available as to what the discussions have been for your specific department or workplace.
Okay. Thank you so much, Sharon. So we're closing to the end of our webinar this evening. We just wanted to say thank you very much for everyone who joined us and for your questions, and feel free to send any further questions or queries you may have to our office. Like Sharon mentioned, there will be more education around this topic and other health and safety topics in the new year. You will receive at the end of this webinar an opportunity to provide some feedback. So please take that chance and give your feedback for us. It's very helpful in developing future webinars. And share the recording. When you get the recording, share share the handouts, share that with your locals, your committees, your branch, if you're in a branch, and to know that the recording will be posted in about 24 hours or so on the PSAC BC website. And take care, everyone. I'll leave it on for a couple more minutes in case you need to download the handouts. You're more than welcome to do that. And take care and be safe, everyone.
Thanks, guys. Goodbye.